2015年嘅截取通訊及監察修訂條例草案委員會嘅第11次會議，我哋夠法定人數，我哋又夠時間啦。今日出席嘅官員呢係總共有5位，包括呢係有保安局嘅副秘書長李美美女士啦，首席助理秘書長伍江美妮女士，以及呢係助理秘書長趙文軒先生。喺律政司處方面呢，有高級助理法律政策專員阿簡。
From the Department of Justice, Justice Mr. Godfrey Khan, Senior Assistant Solicitor General, and Ms. Monica Law, Senior Assistant Law Draftsman. On the 6th of October and the 2nd of October, the administration has provided response paper to us. And it's in paper number CB record 275/15 to 16 bracket 01. And if there are no objections, perhaps we'll wait till after the clause by clause before we go over that. If that is the case, we will continue with the clause by clause. Is that acceptable to you? Chairman, for the clause by clause, we may be going through something that is completely separate. And we are talking about some technical points with the information still fresh in our mind, so it will be better for us to deal with the information paper first. So what you're saying is that we should deal with the administration's papers first. We've had a lot of discussions in the past 2 meetings anyway. Well, anything to add from the administration? And I think this information paper is given to us at about 6 o'clock yesterday. So it's not a supplementary information. We're asking them to explain the paper. Well, there are several parts in this paper. The first part is related to questions asked by members on the last occasion, that is, whether in the past 9 years since the bill was endorsed, any application for prescribed authorization involving information subject to legal professional privilege, LPP, or journalistic material had been rejected, and whether any prescribed authorization had been revoked by a panel judge on the ground that there was a material change in circumstances which involved LPP information or JM. We've gone through the annual reports in the past years. You will find the information in paragraph 2. That there were some cases in which the panel judges had refused applications. However, the reports have not set out the exact yearly figures. And in the past 9 years, we can see from the annual reports that after a prescribed authorization has been issued and the law enforcement agencies found that they have obtained LPP information inadvertently, there are 9 cases. And in each case, the LEA has immediately made a report to the panel judge. After the panel judge has considered whether the cases still comply with Section 3 of the bill, the panel judge decided to revoke the authorization for 8 cases. The remaining case occurred in 2011. The authorization was allowed to continue, however, additional conditions have been imposed. The Commissioner, upon review of the case, decided to classify this case as LPP information having been obtained. In relation to journalistic material in those 9 years, there are 4 cases, 3 of which have their authorizations revoked. The remaining case occurred in 2009. The panel judge, after considering the situation and Section 3, decided that the conditions are still met and the authorization was allowed to continue. That's the first part. Would you like me to continue with the other parts? Yes, please do. Last time, members expressed concern as to whether LEAs are required to retrieve devices deployed in a covert surveillance operation after its completion, and the need to set out such requirement in the ordinance. We would like to make it clear, as we've done orally last time, that in the Code of Practice, paragraphs 136 and 137, the requirements have been set out clearly, stating that surveillance devices should not be left in the target premises after the completion or discontinuance of the operation. And when the prescribed authorization was issued, it clearly states that within the periods of authorization, the surveillance device, if deployed, should be retrieved before the expiry of the authorization. But in some cases, it may not be reasonably practicable to retrieve the device before the expiry of the authorization. And in such case, the LEA will have to do a lot of work as a safeguard. They have to apply for a device retrieval warrant, and at the expiry of the authorization, if the device has not been retrieved, and if they think an application for a warrant is not to be made, the decision should be approved by the head of department, and the head of department will have to submit a report to the Commissioner stating the reasons and the decisions, the reasons for it, and steps taken to minimize possible intrusion into privacy by the device. And the Commissioner may carry out a review based on information provided and decide whether the decision of the head of department is reasonable. The arrangement has been set out in the Code of Practice, which is promulgated pursuant to Section 63, and is set down by the Secretary for Security. Non-compliance with the Code of Practice, as shown in previous cases, amounts to non-compliance with rules, and officers are subject to disciplinary action, and in more serious cases, more severe penalty. When it comes to the management of device, which is of concern to which the Commissioner has attached a lot of importance, the Commissioner requires the LEA to track the movement of the devices and have them properly documented, and it has been done. When devices are returned to the device store, it will be documented as well. The Commissioner will check the device registers to check against the records received from LEAs. So there is a very stringent monitoring in relation to surveillance devices. Next, we move on to the term retrieve or retrieval. Last time, members asked what is meant by retrieve or retrieval. We found that in the Interpretation and General Clauses Ordinance Cap 1 and the ICSO, there is no definition, no clear definition of retrieve or retrieval. But in general, retrieve means to recover, regain, get or take possession of, or to bring back, or cause to bring back or return, to bring back from or out of a place or state, to rescue or save. What is more important is that under the regulatory regime of the bill, devices used for surveillance will have to be retrieved before the expiry of the authorization, and where it's not reasonably practicable, clear reasons will have to be given, and the Commissioner has the right to review the decision of the head of department. And as to whether there has been any cases in which surveillance devices have gone lost or could not be recovered. And when it comes to covert operations as defined in the bill, there has never been any case in which a surveillance device has gone missing or cannot be recovered. We have confirmed with the LEAs, and they have also concurred with us.
And finally, in our reply, we mentioned 46(3), the meanings of without prejudice, to 53(4) of the existing ICSO, and except as otherwise provided in this ordinance. So what is the meaning of this? Now, we're trying to explain this. Now, the existing section 46(3) of the ICSO provides that without prejudice to section 53(4), for the purposes of an examination, the applicant is not entitled to have access to any information, document, or other matter compiled by or made available to the Commissioner in connection with the examination. But on the other hand, in section 53(4), provides that except as otherwise provided in this ordinance, the Commissioner shall not be required to produce in any court, or to divulge or communicate to any court, or to provide or disclose to any person any information, document, or other matter compiled by or made available to him in the course of performing any of his functions under this ordinance. So what we're trying to say here is that the Commissioner, while discharging his duties, if he should discover that any covert operation is taken which should really be bound by the ICSO, then the affected party should be notified. So this has been made clear in the ICSO. And the ordinance also states that in the divulging of information, the Commissioner will have to provide an annual report to the Chief Executive. And there are many items listed there. For example, the number of such cases, number of rejections, the main categories of the crimes. So all these will have to be compiled and made available. And according to this ordinance, after the handling of these information will have to be divulged. So the Commissioner making disclosure is clearly confined in the legislation, appropriate to his particular responsibility. And then in 46(3), the sentence I quoted provides that if the Commissioner were to examine the materials, then those making the application to the Commissioner has no right to have access to those examined materials. And this is to protect the Commissioner during his course of examining may have divulged information or covert information of the LDAs, but for the information affecting the person in question will have to be made known. So whether or not the person in question is proved not guilty, he or she has the right to know, and the Commissioner must make it clear to him or her. And there are basic information to be provided to the Commissioner, for example, to confirm the name and some basic information such as address. And these are, of course, personal information. And last time members asked whether it is possible for the person in question to take back that information. And verbally, I have asked the Secretariat that this is okay under the personal privacy ordinance. The information can be returned, but only those information stated and nothing over and above those. So in other words, the Commissioner is protected in the sense that he has no need to divulge or communicate materials to other parties except in the annual report to the CE. So, Chair, this is briefly my summary. So, thank you, Deputy Secretary. Now, for your explanation of the paper. James Toll, I asked about paragraph 5, about the retrieving. Now, I think the policy is clear, and that the device should be retrieved before the expiry of the authorization. But you admit that sometimes it's not reasonably practicable to do that. So, for example, in the last few seconds of the authorization period, and suddenly there is something very important coming up in the last 5 minutes, and without that 5 minutes, you may have lost material information because there's a sequence of events. So I understand that. But the question is, when you are acting on this policy, you are aiming to just satisfy the requirement of the Code of Practice. But this is something pretty basic. And as you said, because you want to protect a person's privacy and to make sure that the covert operation is not made public or made known. And so you have to retrieve the device. Now, I think you can resort to something other than the law. But then to protect privacy, and then by terms, in terms of policy, you're only relying on the Code of Practice, I feel that is not enough. Now, I hope the government, now, in your explanation in paragraph 6, you said that this has been working well in the past, but now that we have a chance to rewrite this, now, because several years ago, this point was not raised because there was not enough time. But then, policy-wise, the retrieving of the device. Now, of course, nobody knows how the device operates. Would other people be able to get those frequency and then to monitor conversation and to be remotely broadcasted? Is it necessarily encoded? Now, of course, you want it to be coded. But then if it's recorded as an audio sound, then that's even worse. And is it possible that, periodically you will access the information and then put the device back? So all sorts of possibilities. In other words, the existence of the device affects confidentiality or privacy. Now, maybe there's a possibility of deactivating the device or turn it off. And is it possible that somebody can actually turn it on by a certain construction worker, or somebody inadvertently tamper with the device and then turn it on? So you cannot guarantee its safety. So from a legal point of view, you must retrieve the device as a matter of precaution and security, and you mustn't be satisfied with just complying with the COP. Or you can charge somebody for professional misconduct if something were to happen. Because violating the law and violating the COP is not the same. So I think the government should make use of this chance to do some amendment, rather than just resorting to paragraph 6 and say that it has been working well for some time. I don't think you can convince people that the COP already is enough. It should be raised to a higher level. Okay, so Mr. To is now repeating an earlier point that the COP is not enough and that something at a higher level is needed. Right, so Mr. To has repeated his point. Ms. Lee. Now, the ordinance has worked for 9 years, and in all the covert operations, the LDAs were able to retrieve the device before the end of the authorization period. So this is actual experience that we have, and the LDA is very concerned about retrieving the device, and they have a very good track record. Okay, a COP is an administrative measure, but now is it really necessary to write it into the ordinance? Now, you members can consider, because the ordinance has already stipulated a system. That is, if the device could not be retrieved within the stipulated time, there is something for the LEA to do. They can put in a sort of a warrant, a device retrieval warrant. And as we say in the paper, now if the department decides not to retrieve the device by using the warrant, so for example, if you take out a covert operation and the agent or the operative has already taken the device and took it outside of Hong Kong, so you cannot really retrieve that, and you have to issue a retrieval warrant. And then some department might think that even if the warrant is issued, it is not practicable, and it must have the consent of the department head and also the view of the commissioner. And the commissioner could actually say no. So there is a check and balance there. And the way we see it is that the existing check and balance is enough to make sure that the device is being dealt with properly. And we have a track record of 9 years, and nothing untoward had happened. Okay, now what you're saying, Ms. Lee, is that if it cannot be retrieved, now in the example you quoted, was somebody took it away from Hong Kong, but the final decision rests with your department head, not a judge. Now, in other words, your department can decide something which can intrude into people's privacy. Now, it is not a judge now ruling for the device, but then you want to take it out. Now, if it's done by a judge or of a judge agreeing that you cannot retrieve it, so the request is now abandoned, then even if that device were to affect people's privacy, it would have a basis based on the view of the judge, because it could not be done, it could not be retrieved. But now it is within your own department saying that, okay, leave the device in the house. And he makes all the final decision. So this is not made by a court of law. It's not really protecting privacy, because the department head makes all the decisions. And using your example, and he carries it in his shoe, for example, and then suddenly the device is reactivated. But you have to remember that it's the department head making all the decisions, and I find that problematic, Chair. Ms. Lee. Now, the covert operation, the decision-making body would have to make all practical measures to make sure that once the operation is finished, the device has to stop working and to be taken away, retrieved.
And if retrieval cannot be done immediately, the device will have stopped working anyway. And Mr. To said that, well, it's stopped and it's not retrieved and it will continue to operate, then it's a breach of the ordinance, because if you want to reactivate the operation of a surveillance device that is not retrieved, then it means that it's a fresh operation. And without an authorization, the LEA officer has committed a very grave breach. And there is a very stringent check and balance. But the fact is, you are unable to stop it. Of course, if it can be stopped, then it's a breach. But what if it cannot be stopped? That the signal continues to be transmitted, and you can't possibly say that it can be stopped. Looking at the operation in the past, that is something that we have been doing. All devices can be stopped. I'm not saying that it will happen, but in the design of the system, we have taken into consideration what Mr. To said. What will happen if it can't be stopped? Well, if that is the case, then the LEA has the duty to stop the signal emitted from the device. If it cannot be stopped immediately, there may be a lag of 5 seconds or a minute. You will have to stop receiving the signal and cannot use the information thus received. Mr. To is concerned about something that a decision has been made by the head of department. Does it mean that you will have to that a report will have to be made to the panel judge? That is such a mechanism in place? No, not the panel judge, but the commissioner. Let me say it again. At the expiry of the authorization, the devices are not retrieved, and the head of department has decided to not make an application for a device retrieval warrant, then the decision will have to be approved by the head of department, a report made to the commissioner. Upon receipt of the report, the commissioner will look to see if the decision is warranted. So it's not just the decision of the department head. Yes, Mr. Sin Chung Kai. My questions are not the same as those of Mr. To's. paragraph 8, the Deputy Secretary said that in the annual reports there has not been any case found when a device was lost or could not be recovered, and there was confirmation from the LEA. And in paragraph 7, there was about the definition of retrieval. Technologies are different now. Now, people use software to conduct surveillance or interception of communication. And exactly like what Mr. To said, unless you uninstall it, deactivating it may be easier than uninstalling it. So if you use spyware, how do you retrieve it? So how do you classify such cases? Yes, I agree. Some operations will have to be covert. And I don't want to ask if you've actually used spyware. But how do you classify it? You said, there's not been case when the device could not be recovered. But we are talking about hardware. What about software? You either deactivate it or you uninstall it. You can't physically take it away. This point has been discussed many times. DS, please repeat what you've said. Let me say this again. In relation to our arrangement, if the device involves a program, the responsible officer must, before the expiry of the authorization, make arrangements to stop the operation of the device and retrieve the surveillance device. Whether it is a program or not is the same. Steps will have to be taken to make it happen because the definition of device is quite broad. Programs is only one of them. And I can tell you that there is no difference whether it is a hardware or a program. In paragraph 7 is the general meaning of the word retrieve. First, you will have to stop the operation, and the second part is to retrieve the surveillance. And about the second part, they will have to try to think of a way to do it. Let's say if it's Trojan horse, you won't be able to take it away. And last time it's already said that it's impossible. For operational details, if we discuss it in an open meeting, it may affect the enforcement operations of LEA, so I'm afraid I can't explain in detail, but there are ways to do it. Mr. Charles Mock, I don't want to get bogged down on this point, but I'd like to say my piece. If the administration is talking about the spirit of the law, that devices include spyware, and under the law, retrieval is the same as retrieving a hardware, a piece of device. I think to a certain extent, yes, it can put our mind at ease, but we're talking about how to retrieve it. The government said that it's difficult for us to give you the exact details. I just want to make a comment. If that is the case, that means, when it's installed, as you know, that spyware, it may be sent through an email that's opened. If you ask security experts, if you want to take it away, it's a very big thing. You have to uninstall the whole thing. Maybe that's the way how the law's written. Maybe in a way the code of practice said that, don't use it as far as you can because well, if you want to retrieve it, you may have to just blow the whole thing up. You can't guarantee as how you will do it exactly in the future. If the government abides by the rules and the provisions, then I advise you not to use it, because I can tell you that you can't take it away once it's installed. I don't know how you can answer me, but that's what I think. And as to really whether that really is the case for LEAs, we don't know. We just hope that they abide by the rules. The ordinance empowers LEAs to use different devices, which includes program, in different situations, and they will choose what type of devices to use, and including under what circumstance they will use a program. You will give us a written reply, is that right? Yes, we can do it. About software. Yes, we can give supplementary information in written form. Mr. Christopher Chung, why can't it be retrieved? You've been reading computers for so long, and how come you don't know? There are two ways. One, manually. You go to the machine and delete it, or use software to uninstall it. Secondly, there is another program in the machine stating that after a certain day the software will be uninstalled. It's the way you write the program. And you write it in the program how the spyware will uninstall itself. There is a way. Whether it is done manually or automatically, it may damage the original program, and you have to take that into consideration. Well, you may damage the machine in a certain way, and I'm sure security experts will find a way. If you decide to install it, you will have to find a way to uninstall it, and I think you should leave it to experts. You think that it can't be taken away. Well, we have smartphones, so you install a lot of apps, and you can uninstall them. And it's about how the program is written. Do you have anything to say in reply? I don't have anything to add. All I can say is that the law has included program as device, and as to whether to use it and under what circumstance it is used, and how it's to be retrieved, I think it's for the experts to answer. Ms. Emily Lau, I agree that you asked the DS to give us a written response to explain in detail about technical points, whether something can't be retrieved. Maybe it's like Mission Impossible. You put something there and it will stay there for a day or 10 days. Afterwards it will destroy itself. Just give us a paper. And paragraph 6, we should make use of this amendment to write this into the law. You can't just say that, well, it's been working effectively, there is no need. It's an appropriate time when we have a legislative amendment. You're talking about penalties and misconduct in public office, just like what's happening to Donald Tsang. Then why don't you write it properly into the law? I don't understand. Unless you say that there won't be any penalty. If there will be penalties, then make it clear. And remind us, how many officers have been involved, or there was none? How many of them have been through disciplinary actions or prosecution? about LPP and JM. There has been occasions when material has been inadvertently obtained. Can they use the information obtained? Are there any safeguard against it? It's obtained inadvertently. Then how can you ensure that the information has indeed not been used? Yes. Well, there are different parts to the questions. First of all, I'd like to say that when it comes to device retrieval, in the past 9 years, since the ordinance has come into effect, every time the LEA was able to retrieve the device in accordance with the code of practice before the expiry of the authorization, and is properly documented as well. So the track record has been good. And you're asking whether, well, what if one time they are unable to do it? It's said in the law that if the retrieval is done after the expiry of the authorization, then an application for retrieval, device retrieval warrant will have to be made for the panel judge to decide. And there is also a third-tier safeguard. If the LEA thinks that even with an application of the warrant, the device can't be retrieved. Say, for example, you know that the device has been destroyed, maybe in a fire, and the device was installed in the premises. Then the head of the department may decide not to make the application, but it's subject to the review of the commissioner. So it's not just for the head of the department to decide. A report will have to be made to the commissioner for the commissioner to decide, and it's clearly stated in the law. So for different situations, there is a system designed to act as checks and balances to ensure that devices will have to be retrieved. Otherwise, it will be reported and reviewed.
And because of this, we do not see any urgent need to write in anything to the effect that the device has to be retrieved, because in English, by default, the device has to be retrieved. Failing that, there will be a lot of implications and resulting in penalty. And secondly, in the LPP, before you go to that area, now, but you are saying that it is, at least in there is such a possibility resulting in misconduct. So what I'm saying is, why not write this in the paper? Because you've said it so nicely. And because of the amendment opportunity, well, why not just write it in? Because you agree that this is something that would be result in a penalty. Now, I can accept that the present practice is acceptable, but members are now suggesting that this should be made clear in the amendment. So now, what is the view of the government? Now, to make it simple, well, you can say that it is okay and there's no need for amendment. Or if you say that maybe amendments should be made. Now, I think retrieving the device is mentioned not just in the COP, but in the ordinance itself. It also touches on this issue and provides a legal framework for the retrieval of the device. So you're saying that there is no need to make any changes. So we don't see the need to make such amendment. Okay, let's move on now to the LPP. Now, if during the period of authorization the LEA discovered that it has obtained LPP information, he has to report to the panel judge, and the judge will have to decide whether to continue or not. And again, in the past, the judge very often will withdraw the authorization, but there were cases where conditions were imposed to allow this to continue, and the LPP material so obtained cannot be used for further investigation. It has to stop at there, and cannot be used for further investigation. And so these have to be destroyed as soon as possible after certain steps have been done. Now, what protections are there that such information will not be used, because the information has already been obtained? So is there any mechanism to protect that those information will not be used? And what is the meaning of to be used? I think that's Ms. Lau's concern. What does that mean? Not used as in court for prosecution, or what? Now, there is protection in the ordinance. Now, in Section 62, that even though the LPP was obtained, those information will have to be legally privileged. And 51(9) says that all such intercepted materials would have to be used for the original purpose and the minimum to be used. And if it involves LPP, then we have to look at 59(1)(c) and 59(2)(b together, which really says that any such LPP information obtained must be destroyed as soon as practicable. So this is the relevant legislation. So what is the meaning of use? Well, it will not be used for investigative purposes, because all these covert information obtained, but at that particular point, the information will have to be stopped and the information destroyed and cannot be used for any further purpose. James Toh. Now, can I ask about the ordinance and the COP level? Let me make this clear. I'll try to do that. Now, the basic law says that the protection of privacy is by law, is to be done by law and not by COP or administrative measures. So you are now saying that a retrieval warrant can be issued, and if the device is not retrieved, then the department head has to give his green light. Now, but if it's to be done by a judge, you have to make an application. But now, the non-retrieval or the non-issuance of the warrant, then the judge has no chance to say no. And this is not achieved by law in protecting privacy. It may be subject to judicial review or be accused of anti-constitutional. Now, and even if you claim that you have a very good track record, now I don't know whether the legal advisor can give any information, or can you give us a legal reply? It may be against the Constitution, because you're not relying on the law to offer such protection. I believe the administration can at least give us a paper on this. A legal advisor. Mr. Toh, are you saying that Basic Law Section 30, the protection by law of the Hong Kong public, and if necessary, the government can give an explanation. After the authorization period and the device is not taken out, then whether this should be stipulated in the primary legislation, or should we rely just on the COP? Now, I think this is Mr. To's major concern. Now, the basic law really says that regarding the protection of privacy ordinance, so this is Article 30. Freedom and privacy of communication of Hong Kong residents shall be protected by law, and no department or individual may on any grounds infringe upon the freedom and privacy of communication, and so on. Now, well, otherwise the authorization period will be extended. Okay, so we are now introducing Article 30 of the Basic Law. So now, Mr. To is of the view that Article 30 needs to be addressed, and I agree that a paper has to be provided to deal with this. So, the Chair, now, paragraph 6, paragraph 5, Chair, says that there is an application of a device retrieval warrant, but the non-application requires only the approval of the department head, not the judge. So it is not the case that the decision rests with the judge. Okay, so Deputy Secretary. Chair, now thank you for your question, Mr. To. We can provide a more detailed paper, but the short reply is that the ICSO aims to address the requirement of the Basic Law, and that is anything which infringes on privacy has to be written into the law or ordinance. So for any covert operation or interception of communication, there must be a legal ground for doing that. Now, the concern about retrieval of the device, now issue is very clear. Before the authorization ends, the device has to be retrieved. Now, but why do we write it into the Code of Practice? Because the operation must finish within the authorization period. And Mr. Sin was saying that if the dead device cannot be retrieved, but then the device is already not working. And maybe in the case of fire, as mentioned by Ms. Lee, these are operational changes, and so it's written in the COP. So it is really very, very clear. Now, your example is that it should stop before the end of the authorization. But if the device is still infringing on privacy and it is still working, you still have to retrieve it. So the infringement is you are not using a matter of law to apply, and the non-application is not decided by a court of law. You are only relying on the COP. I think that Mr. To has made himself very, very clear. Okay. Claudia Mo. Now, the communication privacy has to be protected by law unless you are talking about public security being affected. You're saying that LPP information having been obtained it will not be used and they would be destroyed ASAP. Now, I would like to ask, now LPP information includes lawyer and client exchange of information. Now, apart from that, what about regarding medical doctors or other professions? That's my first question. And secondly, who decides that the information obtained is legally privileged? And number three, well, who decides that this is legal professional privilege and we mustn't use it? And then, well, journalistic material. We at the moment do not have this shield law but within journalistic material, well, let's say information obtained by a certain journalist and placed in the computer and then obtained by the LEA, but the information in fact contains those provided by lawyers, which are indirectly LPP. Now, I think we are talking about LPP here, so I'll ask Ms. Lee to respond. Or Mrs. Ng, right. Now, the LPP information is, well, refers to both verbal and written information, and there are exceptions. If the communication is for criminal purpose, then this is not LPP information.
So the protection has been clearly stated in common law that it has to be protected by law, unless there is crime in place. But, well, are there then any special treatment, say for example, well, conversation between the doctor and the patient, and between the a person and a man of the cloth? Well, we have protections again on LPP and JP, and in relation to conversation between the patient and the doctor, I will defer to our lawyer, Mr. Kan, Senior Assistant Solicitor General. In relation to other privileges, in Section 3, in relation to issuance and renewal, there are already information set out that when the panel judge decides whether to issue or continue the authorization, apart from considering the level of intrusion, the panel judge will have to consider other circumstances. So lawful rights which may be affected by the operation of the LEA will have to mention it in the application, and the panel judge will have to take that into consideration before deciding whether these conditions are met. In short, there is no express provisions. If it's privacy, then it's related to the PDPO. Is that right? You've said it very clearly. There is no express provision. Well, yes, it's very clear when it comes to LPP. For the others, you have to refer to this situation. It may be used, it may be disclosed. But when it comes to public security laws in any society, I think you have to rely on trust. Well, for public security reasons, the people give a power to the enforcement authorities. It's just like the Patriot law in the U.S. You said that we will not cross the line, but there are no express provisions. So it depends on whether you trust the law enforcement agency. It's rather unsettling. Should there be consideration of should there be other examples? Say, for example, during a confession to a man of the cloth, or a conversation between the patient and the doctor, and some indirect information in journalistic material. Or should that at least be mentioned? It's not part of the amendments in this exercise. So will you further consider it, Mr. Khan? In Schedule 3, it says that the LEA, when applying for issuance or continuance of authorization, they will have to specify that apart from the impact on the target, they have to specifically mention whether there will be any impact on anyone else or any other people that will be affected. If the operation affects a priest, a doctor, a patient, then in the affirmation they have to mention it. And conditions under Section 3 includes other conditions, say for example freedom of the press. The panel judge will consider everything, balance the different factors before making a decision. Mr. Sin Chung Kai, just now the DS agreed to give us a written paper about how they deal with spyware or other software. But I'd like to say something else. Mr. Chong mentioned, told us about what he thinks, and so did Mr. Mok. Mr. Chong's not wrong, because there is nothing that you can install and not and can't uninstall, but it's about complexity. Yes, of course, if you plant it there, you'll be able to take it out. Before you take it out, deactivating it is not equal to retrieving it. It's just that it's not active or is not functioning. It's, say, software that is planted into a smartphone or a computer. But when you take it out, can it be done? Can you? Yes, you can do it. But it's more difficult to take it out than just uninstalling an app in a smartphone. Because well, it's easy to install something without that person knowing, but it's difficult to uninstall it or take it out without that person knowing about it. And just now, is it the case that, is it the stance of the LEA that if it can't be taken out without the subject knowing, then it should not be planted in the first place? But even if you can take it out, in most cases there are traces that it was once planted there. For some software, even after it's been uninstalled, there are still some folders, empty folders left behind. And sometimes the files are left in the recycle bin, and you'll be able to see it. So if you use the definition in paragraph 7, that is the general meaning. That is, well, you take it completely out without that person knowing. Say, for example, those spyware or some zombie programs, especially doing it remotely, it will be even more difficult. I'm not a security expert. I'm just talking about some common sense. Yes, you may not be able to give us the details, but you can at least give us the principles after you've spoken to your security expert. We have to ask the questions. Times have changed. 9 or 10 years ago when it was enacted, when it came into effect 9 years ago, using software for surveillance was not commonplace. But I can see that it will be more and more commonplace in the future. It will be more and more prevalent. So I can't give up the chance to ask the questions. Please take that into consideration and include it in your written response. Okay, now, Ms. Whittle, just a very simple question. Mr. Sin and a number of members asked about spyware. So I asked the administration not to treat it as confidential and refrain from answering it. Well, what about a computer security unit? Do they know how to uninstall a program planted remotely? Because you may not be able to retrieve it if you've never done it before. And I would like the information in the written reply. I think that they would definitely not answer you because it's highly confidential. They won't be able to tell you whether they can do it or not. Well, at least they will know about the situation now. So how will you answer? Of course, we will answer if we can answer. And if there is anything that would reveal to criminals about our operation, we have to be very careful. Of course, we are above board and we don't mind, but if you have a secret agenda, then you will hear more than what we say. So we don't want to give them unnecessary information. No, I just want them to tell us whether they have the technology to take it out. We just want them to tell the electrical. Well, the electrical knows, everyone knows. Maybe they are only concerned about planting it and not taking it out. Mr. James told. I want to ask about the prejudice or infringement. Say, in a room, you install a spy camera or you wire the room. You may take something out from, say, from the wall, and then you patch it up. The panel judge will anticipate the damage. Say, for example, if you take away the socket and you put it back, and you may have to do some plaster work or use a little bit more electricity that is paid by the subject. When it comes to spyware, my concern, say, well, there has been ICAC cases. I think there is something to do with someone taking bribes in the speculation of warrants. If spywares have been used, and if you don't take it out, and it's reported to the commissioner, in the end, the whole system may be down. Of course, you don't want that to happen. But if there is damage, or if it significantly slow down your system, when you make the application or make the application to not retrieve it, is there such a consideration in the code of practice? Whether it is the head of department, when you make the application, the panel judge may ask you questions, but if an application is not made and the decision is endorsed by the head of department, a report is made to the commissioner. It may not occur to the commissioner to ask whether the installation of the device will cause any damage. Maybe some data is erased as a result. The system slowed down, maybe just half a second, and hundreds of $1,000,000 has been lost because it's in a split. You're slow by a split second, and you lost the deal. You have to make an assessment. I'm not even talking about when it's found out. But the thing is, well, all the procedures have been followed, and everything has been complied with, and the company or the individual has lost billions of dollars, and the person affected or the company affected cannot seek compensation. You have to take that into consideration.
Chair, the scenario described by Mr. To, now I think I can use this example. If you are taking up an action and you break down the door and then you damage the lock in order to break into a premise, so maybe a hole is created, so this happened. Now, but to strike the balance, if you are doing it legally because you have a search warrant or other legal grounds, you are in fact balancing between protecting and then also destroying a certain property, and the society would accept this particular damage to the property. So similarly, for covert operation that we have to undertake, if you have to revert to Section 29 or Section 30 for further authorization to install a certain physical device, your means of doing so would actually be like the example I just quoted, but maybe to a much lesser extent. Because if it's a very big damage, then people would discover what you have done. So the panel judge under Annex 3 would require the LDA, now when they are asking for prescribed authorization, now the certain device to be used and its impact on people, these have to be told to the judge. And this includes the scenario that you described, Mr. To. Certain people's benefits may be affected, at least on the surface. But then a balance has to be struck as to weighing the pros and cons, and the judge will make a decision based on that. So in Annex 3 at the moment, we do have that. There is a prescription that impact on any individual will have to be described. Now, I would like the administration to consider, okay, you talked about breaking down a certain wall, or even if you want to make certain arrests, you have to use tear gas bombs, right, and so on. Now, but in the case of a retrieval, it is not the decision of the judge. Now, the authorization is easily done. Okay, you use a certain spyware, and you have a certain authorization period, and the judge would agree because you have indicated a period of operation. But we're now looking at the latter end of the application. Your scenario is that this is a necessary damage. Okay, we understand. But if the device cannot be retrieved, and every time there is a lag of, let's say, half a second. Okay, there is the actual lag, and then the actual trading was affected. But then you discover this many months later. That's possible. But the judge would not have a chance to revisit the issue. And it is, in fact, the department head making the decision. And the department head may have in mind the corporate interest of his department. So it is not the judge making the decision, and I feel that this is a downside, because when first giving the authorization, the judge has in mind that the device could be retrieved on time. So if you do not have an independent person allowing this necessary evil to continue, this is pretty serious. Okay, so again, Mr. To is emphasizing the need to have a legal description or resorting to ordinance rather than COP. Now, this is looking at it from a damage angle, whether you destroy a light switch or whether a trading suffers from a 1 second or 2 second lag, resulting in a loss of $1 billion. The issue is when non-retrieval takes place, there might be serious consequences. Okay, now, Chair, I would like the government to respond to this in their paper to us. What are the rationale, and is there any way to get over this? Okay, Mr. To, now a technical point. Now you mentioned two things. One is to stop the device operating, and the other one is actually to retrieve it. Now in your COP, is it by necessary implication, or is it that the LDA can do one of the two things? Well, they should do two things. Both. They should do both. The concept is very clear. Now, but okay, it's not bound by law, but in your COP, I'm not reading this very much in detail, but there are two concepts, right? So, deactivating and retrieving. Now, I confirm that this is, and they have to do both. So, as Mr. To said, when deciding on what device to use, they should consider that they have to stop and then to retrieve the device. So this is in the COP, to stop operating and retrieving. So this is the whole thing they have to do. But what about the non-application of the retrieval warrant? Now, it will require the head of department's approval. Now, there are circumstances, and I've quoted examples, where the device cannot be retrieved. And still they have to do something. If it cannot be retrieved, and even applying to the panel judge for a retrieval warrant, it cannot be carried out. There must be approval from department head. And for example, the premise has been burned where the device was installed, or drowned underwater. So this has to be reported to the head of department, and assessment has to be made, as Mr. To was saying. If it could not be retrieved, it might infringe on privacy. So an assessment has to be made, and not just to a very simple assessment that this cannot be retrieved. And this head of department's decision has to be reported to the commissioner. And the commissioner can have a chance to look at this. So is the COP clear? The non-retrieval of the device is one thing, but then the device would have been stopped. So there are 2 points here, right? Because it could not be retrieved, the device has been stopped working. So is the COP clear on this? Yes, the COP is clear that the device has to be stopped, and then on retrieval there is a difference, 2 scenarios, whether it could be retrieved or whether it could not be retrieved. The legal advisor. Thank you, Chair. Now, the government can supplement. My understanding of Mr. To is that, okay, retrieval is one thing, but if you don't retrieve, it must stop the operation of the device. And the government can supplement on top of what Ms. Lee has already said. You need an authorization to intercept, and if the device has done its work, then it must stop working. Because if without the authorization, the interception cannot take place without going against the law. So if the retrieval cannot be done, the working of the device must be stopped. So this is just another angle to look at it. Yes, agreed. Yes, I can. Well, let's say the device is a transmitter, transmitting frequencies, shortwave to a certain listening capacity nearby. The LA's point is that, okay, I will not listen to this. But then if the transmission continues, because the battery is still working, so those in the vicinity with the right receiving frequency, or even inadvertently receiving that channel, and there is such device available in the market to survey different frequencies, listening to, for example, the taxi driver's communication. And if you do not retrieve the device, and if the device continues to transmit messages, then other people may have access to those information. How are you going to solve the problem? Well, will the department head say that, okay, let's continue? Or will the department head say, as soon as it's transmitting, we'll keep on renting the premise and use interference to interfere the transmitted message? Well, do you have such mitigating measures because the transmitter keeps on transmitting? So if that's the case, you could retrieve the device. It's not like in a fire. Well, not reasonably practicable may not be limited to fire or drowning, or if there is a situation where there is a risk of affecting others and we cannot send those inhabitants out. So it's not reasonably practicable to take it out, and it will allow the transmitter to continue to transmit, but you do not have the authorization. So can anything be done? And if you ask the judge, and of course the judge can make an independent decision, but if it's the head of department, I don't know what he or she would say. Now, I would give you a detailed answer in reply, in writing, but the head of department and the panel judge are very much concerned that these will not be allowed to happen. So we are duty bound to stop the device from transmitting. Because if you allow that to happen, you are acting against the law. But as to how this is to be done is a matter of method. Is it a scenario as you described, or in other cases? Then I will provide a paper on this. Okay, you have the law is not clear on this. I know you cannot continue to monitor, but then other people's privacy may be divulged to third parties. So let's have a paper on this. Okay, thank you. Page 17.
Is clause 53. We have already gone through that. And on this point, do you have any other questions? Please continue. 53A1. Will there be a paper to tell us or whether they would further consider it? Well, it will be for the next response paper. We're still considering it. Another question. Whether it can be redelegated. Are there any provisions? Because 3 and 4 is about redelegation. Well, the Commission's inclination is that if it's delegated to A, then it's A only. Even when A is on leave, no one can replace A, and A cannot redelegate it any further. And it can only be done in written form. And a number of requirements have to be complied with in relation to confidentiality. Is it the case that, the law states that it cannot be redelegated? The proposed new 53A states that the Commissioner will have to, in written form, delegate its power. It seems that it cannot be further delegated. So you will have to abide by 53 capital A1. That is, will have to be done by the Commissioner in person and in writing. 54. General obligations of departments to report on non-compliance. (54) states that if the head of department is of the view that the officers may not have complied, then a report will have to be made to the Commissioner stating the situation. Former Commissioner in his report pointed out that there is an inadequacy in this section because it only asks the head of department to make a report where there are non-compliances. And in some situation, well, it's not the mistake of his own department. And it seems that the head of department in this case does not have to submit a report. And in past reports, the commissioner has said that when it comes to irregularities, incidents, non-compliance, whether it is caused by the department's staff, the LEA will submit a report, and it should be made clear, and it's his view that we should amend this section to cover another area, that is, where no non-compliance is involved and is not caused by the department or the department officers. Then it's for the commissioner to decide the nature and whether penalties should be imposed and whether the penalties are suitable. So we've added that without affecting other provisions in this part, the head of the department considers that there may have been a failure to comply with relevant requirement in a case handled by the department, but B, the failure is not due to the fault of the department or any of its officers. The head must also submit to the commissioner a report with details of the failure. This is to implement the suggestion of the former commissioner. I don't object to the addition, but I want to talk about the details. Please refer to the original provision in section 54. It says that that any of his officers it doesn't mention anything about faults. And the reason why the commissioner suggested changing it is because the officers argue with the commissioner, saying that it's not his fault, it's someone else's. I don't know what implications there will be. I'm concerned about impacts on other areas. Say, for example, reports will have to be made, which means that as long as it's a non-compliance, whether it's the fault of your own, then a report will have to be made. And when a report has to be made to, say, the panel judge or the commissioner, well, as long as you have not committed any fault, then you don't have to make a report. The reason is that the reason 2 has to be added is because you have interpreted the original section in such a narrow way that the commissioner suggested changing it. Even where there is no fault, a report has to be made. And you may say that, well, it's only in the code, not the law. Well, I want a confirmation from the legal advisor or the administration in the entire bill or in the entire ordinance. That no other parts will need to add a similar section 2. Otherwise, there will be a lot more consequential amendments. I address Mr. To's concern. If you refer to the background of previous annual reports, the former commissioner made the suggestion not because LEAs argued strongly with the commissioner. The commissioner saw that the existing provision states that head of any department considers that there may have been any case of failure by the department or any of its officers. The commissioner said in the report that even when it's not related to 54, reports have been made to cover irregularities, and he thanked the LEA's cooperation and their initiative. The Commissioner thought that there is a restriction in the provision and it should be expanded to cover other irregularities. And when it comes to no fault of the officers, there may be technical problems. For other provisions and code of practice, well, in various places, LEAs are required to submit reports to the Commissioner or panel judges on a lot of things. So far we don't see that it will harm the requirement to submit reports in other places. And we have consulted the panel judge and also the Commissioner. Mr. Khan. (54) is about whether the LEA has committed any non-compliance. So it's different from other provisions. The existing 54 is about a possible, is about cases where the head of department considers that there may be failure to comply. As the DS said, as the PAS said, that the focus is about the head of department, and about failure that is out of the control of the head of department. When instead of arguing that it is out of their control, adding another provision may be better. Mr. To. If possible, please confirm in writing that you have, because I see that there are a lot of provisions relating to submission of report, so I suspect that there are other provisions. Just go through the entire ordinance to confirm that adding subsection 2 will not affect similar provisions, that it will not inadvertently narrow the scope of the other provisions. And in the new 2B, it says that not due to the department or any of its officers. 54 includes officers, including any disciplinary action taken. If it's not the fault of the officer, if it's the fault of the telecommunications company. Will there be improvement measures or something like that in the report? PAS. Well, it says that a report with details of the case, including any disciplinary action taken. I think it's easy to understand. When the LEA thinks that doesn't think that it's the fault of its officers, then there won't be any disciplinary action proposed. And if you look at the reports of other commissioners, and where there are non-compliance, whether it is technical or not, there are remedial measures and improvement measures. Say, for example, change of the code of practice, where the filling of forms should be more careful, whether there should be any checking. Suggestions are made in every case, and the Commissioner will follow up directly with the LEA to see if they are adequate. And that applies to every single case, although it's not set out here. Ms. Claudia Mo, thank you. It's just a minor point. He said that, considers that there may have been any case of failure, a report has to be submitted. I think it's quite problematic. Yes, we have the spirit of rule of law, and you are presumed innocent until proven otherwise. I don't oppose to subsection 2, but subsection 2 says that it's not your fault. It's definitely not your fault, and you still have to submit the report. That means in the past, if a report was submitted, then it's trouble because the head of department considers that there may be any case of failure. But now, when a report is submitted, then it's almost the case that it's nothing to do with you. So the two actually runs counter to one another. I want to hear from the legal advisor. If I understand it correctly, as Mr. To said, that the need to add subsection 2 was because in the past, LEAs thought that the fault is not that of the department or the officers. That's why they thought that there is no need for them to submit a report. There were such arguments, and that's why there is the newly added subsection 2 saying that even when it's not the fault of the department or officers, a report has to be submitted to the commissioner. As members said, this is an additional safeguard. In relation to the conflict suggested, on the face of it, there is no such thing. The commissioner will review the case to find out who's to be held responsible. When a report is submitted, maybe the department think it's not their fault, but the commissioner will review the case, and the commissioner has the power to decide who in the end is responsible.
Okay, we see all these toing and froing of responsibility, and ultimately it rests with the commissioner having the power. Now, the addition of B, now who defines or who decides who is at fault? It says here, not due to the fault of the department or any of its officers. So, first of all, how do you define or decide on the fault? If you feel that you are not at fault, I mean, well, that's one view, one way to look at it. And then the other point about department or any of its officers, here you have another subjective decision. So who is to decide? And finally, it rests with the commissioner rather than the head of department. So no matter what, whether there is fault or no fault, whether it has to do with the department or its officers or not, a report has to be made. So ultimately, a report has to be submitted to the commissioner. And I do not find any problem with this. But then under 2A, are there any loopholes that need to be plugged? I think that's really the discussion. Now, if members are happy with this, we move on to the next one. For 57 and 58, we've actually discussed this. We have revocation of prescribed authorization, and then or a part of it. And we have actually discussed this. And for 57, we propose that under Section 56(1) or 2 is of the opinion that the ground for discontinuance of a prescribed authorization, then as soon as reasonably practicable, cause the interception to be discontinued. And under 2 little a, and as soon as reasonably practicable after he becomes aware that the ground for discontinuance of the prescribed authorization exists, and here we add in or part of the prescribed authorization, and then 2 little b may at any time cause the interception or covert conveyance or relevant part of the interception or covert surveillance, and then also bracket 4, where the relevant authority receives a report under subsection 3, he shall, as soon as reasonably practicable after receiving the report, revoke the prescribed authorization concerned or the relevant part of the prescribed authorization concerned. And then in bracket 5, where prescribed authorization is revoked under subsection 4, here the prescribed authorization or a part of the prescribed authorization. And then we add in 5 capital A, if only part of the prescribed authorization is revoked, the relevant authority may do one or both of the following: A, vary any terms or conditions in the prescribed authorization; B, specify any new conditions in the prescribed authorization that apply to the prescribed authorization itself or to any further authorization requirement under it, whether granted or imposed under its terms or any provision of its ordinance. And then 7, adding in the prescribed authorization or part of the authorization. So these are technical amendments to allow the panel judge, when revoking prescribed authorization or a part thereof, and to introduce new conditions when considered necessary. The 5 big A can you give us a scenario, because I don't quite get this. Give an example. Any such past experience or in the report, something that you have deduced, the introduction of this 5A. Now this amendment follows from the revoking of part of the prescribed authorization. Now one possible scenario for Section 57 is if the LEA feels that there is no reason for the continuance of the authorization, 57 gives him the power to do that, to discontinue. And then you have to submit a report to the panel judge for revoking. And if the LEA were to revoke the whole or to discontinue the whole authorization, there is no need for changing of the conditions. But if it is a revoke part of it, if for a certain target, if you stop one particular channel for interception, and then the LEA can revoke that particular line of interception, but the other one remains valid, and the panel judge would be given the power to impose new conditions. Okay, so this one is not discontinued, but then there might be other risks. So you need somebody at a higher pay grade to look into this. So with this part of the prescribed authorization, the judge is given the power to modify the conditions. So this is again implementing the suggestion of the Commissioner. So the 5A, the relevant authority refers to the judge. Is that right? Now, if it is for the Section 1, then this is the panel judge. If it's the second category, then it is the authority giving the condition. If it's type 2. Okay, now for 57 bracket 1, you have now let's say it's an inspector. Or does it mean his superior? Now, under this mechanism, the LEA, apart from the team carrying out the operation, they have to have periodic reviews. And this would be the superior. So this superior officer will, under practical, reasonable condition, to apply for the discontinuance, will have to give the order because he or she is a superior officer. I know you're using the original wording, but looking at this again, you know, in the disciplinary forces, if it's an order from superior officer, it's very serious. But to make a speedy arrangement is another thing, isn't it? Will you consider changing the wording? Now, for type 1, you have the personnel doing the review should have to arrange discontinuance. And if you look at past reports, the LEA is of the view that there is no need to continue. So this is type 1. So this is proven effective. We are not doubting that you've given reports in the past, but assuming the history can be rewritten, maybe it was not stated very clearly. Now, this officer by whom any regular review is done is not somebody of the same rank or the person making the application. So this person doing the review, if this situation were to happen, he should give the order rather than to just cause the interception. It would not be the person doing the review himself doing the discontinuation. So it is not just writing a memo, because he has the power to do that. So do you have several tiers of operation? This person doing the review belongs to another team, and then he has to produce a memo to his superior officer. But if let's say it is a chief inspector handling the case of an inspector, so a direct order can be given. Chair, maybe I can supplement. Now, in actual operation, the LEA's review officer cannot be lower than assistant commissioner of police at a pay grade of D2. So pretty senior. and cannot be somebody who is directly or indirectly taking part in the operation. So just to avoid any conflict of interest. Now, but why is the use of the word to cause the interception cannot on the dot make a decision, and the arrangement needed would involve finding out the relevant facts, the details, and what other measures have been in place, and what measures should be stopped, and what information to be kept. So the arrangement is a good wording, and then only with authorization would the discontinuation take place. Now, Chair, now maybe you can go back and think about it. Okay, you've got the view. He should give an order to stop, and then as soon as reasonably practicable, cause the interception to be discontinued. So a decision has to be made. So this is what I'm saying. And he must make such a decision. Okay, there might be other things to follow up. Okay, can you think about that? Because time is up, and we have AOB. We don't have any AOB. And next meeting, 2nd of November, Monday, 2:30 p.m. Meeting adjourned. Thank you.